Welcome. I guess we're going to get going here. It's a little past the hour. Let's do this. And I want to welcome those who are showing up here. Really excited for this event. It's a big topic, and my guests here are great. My name's Paul Hitchcock. I have Lori Halverson here, who is a Vistage Chair doing great things in Denver. Welcome, Lori.
Thanks, Paul. Appreciate you and Harry being here with us today.
Yeah, absolutely. And I have also Harry Barth, who is the founder and senior managing partner of the asset protection, estate planning, and business planning firm Barth Calderon, headquartered in California with about 5,000 clients across the country. Harry's a top speaker, Vistage member, speaker for Vistage and many other groups. And this is a very hot topic, the Corporate Transparency Act. We're going to get into that, what it is, what you need to be focused on, how the filing works, and all of it. But before we move to Harry, Lori, I'd love to hear a little bit about your Vistage practice and what you're doing there in Denver.
Yeah, thanks so much, Paul. As you mentioned, I'm a Vistage chair here in Denver, Colorado, and I have two groups. One is for CEOs, presidents, and business owners. And the other group that I have is for their key staff, so the C-suite. And there are many other levels of leadership for all levels of the organization. And as everybody knows, it's very lonely at the top. So my group is a place to come together for CEOs and peers to learn and grow together. We work through issues and opportunities and possibilities and get outside perspectives like Harry. So I think if I wasn't in Vistage, I wouldn't know about the Corporate Transparency Act. So and I've talked to a lot of people about it, and it seems to be a pretty well kept secret. So Harry, I'm really glad to be here with you, and I appreciate you sharing this with my Vistage members and with my network.
Thank you, thank you, thank you.
Yeah, great. Let's jump in, Harry. What do we need to know?
Okay, so here we go. So let's talk about the Corporate Transparency Act. It's interesting. It's very interesting. What you said about it is very, very true. It's the best kept secret, but it's a major law, and not complying with it is a felony. So it's just, how do you have a major law that's so impactful that not complying with is a felony? So we're going to learn about this today. Some definitional things to report. You'll hear me use the term FinCEN quite a bit. That means the Financial Crimes Enforcement Network. It's a subdivision of the United States Department of Treasury, and it is the division that's responsible for implementing and carrying out the Corporate Transparency Act. What is the Corporate Transparency Act? Well, it was passed in 2021. It was delayed in 2022, delayed in 2023. But kicked off January 1st, 2024. And what it is a registry, so to speak, of every non-exempt small business in America. And that registry is for law enforcement purposes only. Very important to understand, it's not public. It's available for law enforcement and governmental use. And why? Basically, it started back in 9/11, where they're trying to find out who's behind all these shell and shelf companies. And it's important, as we talk today, to understand that the goal of the Corporate Transparency Act is for law enforcement to know who is the real human beings behind an entity. So if you keep that in mind, some of this will make some sense along the way. It applies to every single limited liability company, limited partnership, and corporation, limited liability partnership, limited liability corporation in the United States of America, unless you're exempt. Guesstimate, there are 33 million existing businesses that fall within the confines of the Corporate Transparency Act. And for those 33 million pre-existing businesses, Lori, they have to have their registration with FinCEN complete by December 31st, 2024, by the end of this year. How they're going to do that, I don't know, because when you see what's involved in the registration, it can get quite daunting. For new entities that are formed after January 1st, 2024, they must be in compliance and filed with FinCEN within 90 days of the date that the Secretary of State's office said that they are a viable entity. So it begins with if it's an entity that gets its charter from the Secretary of State, it falls under the Corporate Transparency Act. So interesting to note, at the moment, trusts do not fall under the Corporate Transparency Act. But if a trust owns an entity that falls under the Corporate Transparency Act, then the trust becomes a reporting person. And I'll explain that as we move through the morning together. So it's there are a couple of preambles before we get to specifics. There are a couple of cases in federal district court that are attempting to have the Corporate Transparency Act declared unconstitutional. One of them is a case is the National Small Business Association versus Yellen that was brought in the Northern District of Alabama, basically saying, hey, Congress didn't have the authority to pass this act. And the judge, in a summary judgment at a trial, declared the act unconstitutional. But for everybody, very important to note, because there's a lot of scuttlebutt about that, it's unconstitutional. That only applies to the members of the National Small Business Association. They're the plaintiff. It is not a nationwide ban. So if you're a member of the National Small Business Association, for the moment, you do not need to comply. Everybody else needs to comply. And as of now, the United States has appealed that decision. And, based upon my 45 years of experience, I think that the Corporate Transparency Act is here to stay. Some aspects of it may be declared unconstitutional. The best intelligence is that the 11th Circuit Court of Appeals, which is hearing the appeal, will overrule the Alabama judge and saying the Congress did have the authority to do that. And we don't expect any other courts to come to a similar conclusion. So I think it's here to stay. As with any new law, it's only 90 days in its implementation. There are some questions. The other thing that we need to know is that the government is serious about this. Why are they serious? Let's talk about the penalties for failure to comply. And there are no exceptions. This is maybe one of the unconstitutional issues, but there are no exceptions. So if you do not comply, all right, the fine is $591 a day per violation, no cap. Okay. So if it was due to be filed by the 90th day and we're in the 92nd day, we're already at $1,200 worth of fines that are coming along. In addition, if it's willful, there's up to $10,000 of criminal fines and up to 2 years in jail. It's a felony. And that can be applied at the company level, could be applied for anybody that fails to comply or makes it difficult for a company to comply. It's a whole quagmire of fines and penalties that are quite egregious in relation. You don't have that much if you don't file a tax return, but we do have it here in the Corporate Transparency Act. So let's talk a little bit before we get into actually what one has to do. We're gonna keep today a dividing line for all the entities that were formed prior to January 1st, 2024, and then we'll form an entity together after January 1st, 2024 during our workshop. But let's talk about who does not have to comply. Let's talk about the exemptions. That's very important. And there's a very important exemption that I think that impacts many Vistage members and prospective Vistage members that we'll explore together, but they'll also explain the limitations of that exemption. So the first exemption, there are 23 of them. If you're a public company, you don't need to comply. So if you're listed on the New York Stock Exchange, the American Stock Exchange, NASDAQ, whatever it may be, you don't need to comply. We know who you are. We know who the board is. We know who the CEO is, the COO is. They've been fingerprinted. They've been checked. They've been background checked by the listing organizations, so they don't need to comply because we have the information. We know who the human beings are. Remember, who are the human beings behind the veil. Second, SEC registered investment advisors for the same reason. If you're a registered investment advisor, with the SEC, you've all been background fingerprinted, photographed, and you name it, they know who you are. Same thing. Same thing with venture capital advisors along the way. Insurance companies and insurance producers, they're regulated by the states. Again, to get a license, you go through all the background checks. We know who the people are. Highly regulated financial companies like banks, trust companies, credit unions, broker dealers, and securities dealers are also exempt for the same reasons. We know who they are. Public accounting firms that are registered under Sarbanes-Oxley, that law, to do public accounting, they're exempt. Tax exempt entities like charitable organizations, political organizations, nonprofits are exempt, and governmental authorities are exempt. But the one that's most impactful for your constituency is what they call the big company exemption. So let's explore that together. So the big company exemption, the way it's defined in the Corporate Transparency Act, is a company that has, and these are and, not or. We must have all three of these characteristics to be exempt. They have to have 20 full-time employees as defined by state law, Lori. So it's not 1099 contractors, not part-timers. Under Colorado law, if you're a full-time employee, we need 20 of them. We have to have our office in the good old US of A, and we have to have over $5 million of gross sales. So if we have 5 million of gross sales, our office is in the United States, we have 20 full-time employees, we are exempt from filing under the Act. So, but it's interesting. I'll use myself as an exemplar here. So let's use my law firm, Barth Calderon. So Barth Calderon has way more than 20 employees. We are offices in the United States of America, and we have well over $5 million worth of gross sales. So my law firm, Barth Calderon, is an exempt entity from reporting. But Harry has 12 entities that he owns that hold my real estate, my investments, intellectual property, other types of businesses, media companies, things that I own. All of those are reporting entities. So just the mothership is not a reporting entity, but all of us, they might have a piece of rental real property, a piece of real estate, or they put their vacation home in an LLC. Those are all reporting entities. So important to note is that a subsidiary of an exempt entity is exempt. A brother sister of an exempt entity is not. So if Barth Calderon has a subsidiary that owned a piece of real estate, since Barth Calderon is an exempt entity, that subsidiary is an exempt entity. But that's not great. That's terrible asset protection, terrible estate planning. So really, we don't want the real estate in the main entity, so we would always set it up in a separate LLC and then lease it to the law firm. Since that is not owned by Barth Calderon, but owned by Harry Barth, it becomes a reporting entity. So that's a very important distinction. So the first thing that all of us need to determine, do we have any reporting entities? A lot of people have LLCs, limited partnerships, corporations that they form. They do nothing. They've just formed them. They say they've maintained them for the last number of years. They were going to use them for something and they didn't. All of those are reporting entities. In order to be an inactive entity under the CTA, very, very few people will qualify for that. The entity had to be in existence prior to 2020. It had to have no business in the last 4 years and have no assets. So virtually no company falls within. It's kind of an ineffective exemption. Okay, so let's do some things together this morning. Let's put together a company. Let's put together Lori Harry Paul Co. LLC. All right, in the state of Colorado, and let's go take it and walk it through the CTA. Now, Lori Harry Paul Co. will make widgets. of course. Excuse me. And we will have a couple of DBAs. Widgets are us and widgets are them. So it's a new entity. We put it in effect after January 1st. Let's say we put it in effect. It was born at the Secretary of State's office on March 25th. So we have 90 days from March 25th to do whatever we need to do for our particular entity. So first we determine, is it exempt or not? Well, it's not exempt, so it's got to file. So first we have to file the company. The company is the reporting entity. So the company is responsible for reporting everything about the entity. So in our company, we have to report, what do we have to send to the FinCEN network? The name of our company, Lori, Harry, Paul Co. LLC. And we must include all of our DBAs. DBAs, widgets are them and widgets are us. We then must provide them with the physical address of our company. It cannot be the lawyer's office, cannot be the accountant's office, cannot be a UPS suite, cannot be a post office box. It's where the company has an office. If the office is at your home, our home address needs to be reported to this registry. It's a non-public registry. In addition, we must report a unique identifying number. That unique identifying number in the vast majority of cases was our employer identification number that was issued by the Internal Revenue Service when we applied for that. So within the 90 days, we got the number from the IRS, and now we have our reporting entity. If people have have formed single member LLCs, Lori, those are sometimes what is known as tax disregarded entities. So in there, they may not have an employer identification number. So the number that must be used is their social security number. So their social security number must be reported to get that. So that's the reporting entity. So we've just reported our entity. Now,
Harry, can I ask a quick question? And I know we're going to have questions later, but I have some members who are 100% virtual. They don't have an office anywhere. So what
well,
do you
they
do
live. They live somewhere.
Okay,
their
so
home
it's
address.
the person who started the company, or it would be the three of us.
Well, yeah,
will-
well, that's different. That's not
Okay.
the company. That's the owners of the company. So the company when that company filed to get its LLC status from the state of Colorado, it was required to give an address. That
Okay.
physical address is where the company is, and it it can't be a post office box. It's going to be somebody's house,
Okay.
that they have that.
Yeah.
It's going to be an
Thanks.
address, and otherwise they're not in compliance, and $591 a day. All right.
Thanks for clarifying that.
no
'Cause
no
there are a lot of people.
no exceptions.
Yeah.
There are no exceptions.
Yeah, it's crazy.
Which is another part of the constitutionality question. So now we did that. So before we get on to the owners, for entities that were formed after January 1st, 2024, we now have to file with the FinCEN the company applicant who filed the paperwork with the Secretary of State in Colorado. They have to report. So let's say in my law firm, one of my paralegals filed the necessary paperwork to start our LLC in Colorado. So her name is Cheyenne. Cheyenne would now have to put down her name, her home address, all right, and believe it or not, her passport or driver's license has to be uploaded to FinCEN, or she will obtain, which I'll talk about in a moment, a FinCEN identifying number because she filed the paperwork. And if I am the lawyer that suggested that we form this LLC, the supervising lawyer, I have to comply as well. So already in our company, Lori, Harry, Paul Co., we have the company filing, and we have the company applicant, Cheyenne and Harry, who put it together for you. If you file it yourself, you have to put in as the company applicant. Now we go further. The next step is anyone who is over a 25% owner of our company, all right, which is now known as a beneficial owner of interest, known as a BOI, they must disclose information in the same filing. It is our company Lori, Harry, Paul Co. that has the responsibility now to get its beneficial owners, Lori, Harry, and Paul, to report. We each have 33 and a third. So let's just say we have 30, we have a 1% owner who's the manager of our LLC. So you got a 33, Lori, Harry's got 33, Paul's got 33. We are now the reporting owners. What must we report? Well, I got to report my name, Harry M. Barth. I need to give them my home address. Really not thrilled about that, but I have to give them my home address, and I must upload to them a PDF, color PDF copy of my driver's license, not expired, or a non-expired passport. That must go to, so all three of us must report. If the three of us are not reporting, we're not in compliance. If any one of us don't do it, $591 a day and perhaps jail time. All right. So this is serious. But look what's happening as we're beginning to expand. So as a very important trick under CTA for everybody is that, and most people are going to be using a law firm, by the way, to comply. And you'll see why, because there are things that are legal determinations. The AICPA has said to the CPAs, don't touch this with a 25-foot pole. It's the unauthorized practice of law. And since that there are criminal penalties, I think it's good to have attorney-client privilege when we're putting together. Some CTA filings are easy, Lori, and some, as you'll learn in a minute, are really complicated. But when we turn around and one of the things that we could do, Lori, and should, you can go to FinCEN. Law firm could do most stuff, but we can't do this part. Go to FinCEN, the FinCEN website, www.fincen.gov, and Paul will put it up in the chat.
Yeah, I'm putting it up now.
And open up an account, Lori Halverson account. And they'll want to know, where'd you go to elementary school? What was the color of your first dog? All that kind of stuff. That's why we can't do it. And two-factor authentication. And you get an account, and then you upload your name, your address, and your documents that are required, and they will issue you a number, like a social security number. Lori number 000253652. That becomes your FinCEN identifying number that you're responsible to maintain its accuracy. But now in every single scenario where you are a reporting person, you would just put Lori Halverson number so-and-so. We wouldn't have to give your home address and your identifying documents every single time. So for me, for example, where we do 100, 200 entities a month for asset protection and estate planning purposes for our client base, and I'm the supervising or recommending attorney, I just have to put Harry Barth and my FinCEN number down as the supervising attorney, and my paralegals all have FinCEN numbers. Okay, so we have that. So every beneficial owner that owns more than 25% has to report. A minor does not have to report, but the parents of the minor do need to report. And when the minor reaches the age of majority, it's the responsibility of the company to make sure that the minor reports and the parents are not. It's all a company responsibility, but if we have recalcitrant participants, they can all be fined and jailed. And it's just really it's odd to have this kind of law in America. So I guess there's some challenges to the constitutionality of valid, but I think since this is pretty much in Western European economies, and the more modern Eastern Asian economies already have this type of disclosure. So Interpol and all the others can ferret out money launderers, terrorist financing, and tax evaders. So it's a law enforcement act. So there's another component that's not very clear. So it's not just the beneficial owners of interest, Lori, it's anyone who has any control must report. So remember I said we got 33, 33, 33, and then we hired a manager as 1%. Matter of fact, we could have hired a manager for our LLC that was not even an owner of our LLC, but could make significant major decisions for our LLC. That person must report as someone who has substantial control. Now, substantial control is a legal determination. All right. It could have been managed by the members, right? So the three of us were managers and members. But let's say we went further and we just hired a corporation, an outside company, to help manage widgets are us. So we hired Joe Blow Inc., a Colorado S corporation, to do it. They own no interest in Lori, Harry, and Paul Cohn. But because they may have the decision-making authority in that corporation, they must report. So who must report in a corporation? The COO, the CEO, the president, the CFO, all pretty much most of the C-suite people must report. And if there's a board of directors for the corporation who can remove and replace them, every member of the board must report. Okay, you're beginning to get the picture. So control as well as ownership are critical. Remember the goal. Who's behind the veil? Who are the human beings who can move money around? Because terrorist financing didn't occur in big major companies like Microsoft. It occurred with, and Jill and Joan's hair salon in the back office. Jill and Joan was the front, but in the back office was cartel or terrorist financing activities. That's where the nefarious activity. And so we have this bill targeted to small business. Now, let's go. I was working with the Vistage Chair, and we were talking, doing a CTA webinar for his group. They're in Texas, and everyone in Texas, of course, we're oil and gas. They're all in the oil business. So he says to me, let's walk through this for a second together. He says, I want to make sure I'm right. And he was right. So let me share with you how this happened. He says, when we drill an oil well in Texas, it's a separate LLC because there's a lot of risk. And I'm an asset protection attorney, and it could blow out, people can get injured, you can have pollution problems. You want to limit the liability to that particular project. So every oil well is an LLC. So that LLC, of course, doesn't have 20 employees and has not yet $5 million worth of gross sales. It is a reporting entity. And he says, and the investors, we have investors that invest, in drilling that oil well, but they don't invest as individuals. They invest as LLCs. So we have this oil well, and we have Halverson Investments as an owner, and Barth Investments as an owner, and Hitchcock Investments as an owner, and Smith Investments as an owner. We may have 5 or 6 LLCs as the owners of this oil well. If any one of them owns over 25%, that LLC, its managers, its owners, and its owners are all reporting entities. He says, and usually that LLC is just part of a holding company. There's a holding company that forms an LLC to invest in an oil well. That's true. And that holding company now, which may have 100 other LLCs in it, the holding company becomes a reporting entity and all of its owners and controllers. And of course, if we've done a proper job for estate planning purposes, we don't want all of our investments and everything running through probate or going to a surrogate court if we die or if we become incapacitated. So we put it in our trust. So there are, the family trust, we have, asset protection trust, we have generation skipping trust and dynasty trust, various trusts that are used in the estate planning. Now, although the trust itself is not a reporting entity, if your 1/3 interest of Lori, Harry, Paul is held by your family living revocable trust, your family living revocable trust owns over a 25% interest in a reporting company. So we now have to report who established the trust because the settlor of the trust has the ability to move assets in and out of the trust. Who is the trustee of the trust? Might not be the same as the settlor. Who is the trust protector? Who are the beneficiaries of that trust if the beneficiaries have any power? And sometimes we have something called like a power of appointment, which gives the ability, Lori, to switch or change the direction of trust assets. Very common in more advanced estate planning. Every one of these specialized investment trustees in the trust each have to be a reporting person. So now we started with our basic company, its owners. Now we have to determine and analyze their estate plans and what their trusts have to say and their holding companies have to say. And then sometimes companies are held by a voting trust. in families. So the voting trust has control. So then the trustee of the voting trust is a reporting person. You could have, in the scenario like I just described, 50 different reporting persons and entities in a singular business. And the responsibility of that is our company, it's the company responsibility to do that. And think about, so that's and we have 90 days to do that, Lori, from the date our organization was born. And there are no exceptions. So if we've got 48 of the 50 required, but we don't have the last two, we either got to ditch them or find out who they are, or we can't comply. And if we can't comply, $591 a day for each violation. And if the people that are not complying are willfully not complying, they're subject to criminal penalty. And if we willfully ignore them, we are subject to criminal penalty. It's just a morass of crap as far as I'm concerned. But that is what it is. So that is all the various reporting. So now when we look back, so this is the 90-day period. Now under current law, any changes. All right. So if you move from Colorado to Montana, and now the company is responsible to have you report your new address in Montana, your new driver's license, because let's say you have a FinCEN number. It's a company responsibility to make sure that that's done. So, and we have for that, sadly, under the law, which is hopefully being changed, only 30 days. If we don't report that within 30 days, we're not in compliance. So this is challenging, challenging at best. And now and this is for new entities, we have some idea of who's owning it. We put it together. But when we look back at the 33 million pre-existing entities, here's what we see. You'll see your members that'll have LLCs, corporations, limited partnerships. The LLC agreements, operating agreements are out of date. The shareholders agreements are out of date. The limited partnership agreements, people have died. All right. Kids have inherited. The kids have may put things in their trust. And then the spouses may have divorced. Each one owns over 25%. They don't even know where the spouse lives. The spouse doesn't want them to know where they live. They're not talking. They haven't communicated. It was very acrimonious. You still need to get them all into the CTA because we can't say, well, we have 5 owners. 4 of the 5 owners, we know who they are. The government says is the 5th the terrorist, is the 5th the money launderer. We need to know who it is, or you cannot be in compliance. The good part, if there's a good part, there's a couple of good parts. It's one and done, Lori. Once we file our entity, absent changes, it's not an annual filing. All right. And the only cost you have, if you could do it yourself, is, for a law firm, which I would strongly suggest, to help you determine control and to understand the estate ramifications of the filings that have to be done. And then we have a service that people could use or not use that files it with FinCEN. You could sit down at the computer, go to FinCEN.gov and spend 3.5, 4 hours on Sunday trying to figure out that Byzantine website, or you can have a service filed for $250. Just give them the map of what it is. So the lawyers kind of figure out the map, the filing service kind of files it. It's a bit of a burden on small businesses, but I think it's well worth it.
I'm glad I didn't do it last weekend because we were going to do it. And I thought, what, let's wait and hear what Harry has to say.
Yeah,
so I'm really glad I did. Yeah.
It's not that expensive. We've actually added on to our new entity formations, $390 for all the CTA work and $250 to file it. And for pre-existing entities where it really can get challenging, we're only charging $595 to evaluate an entity, prepare its beneficial ownership and control map, and $250 to file it. So we're not.
That's money spent.
We're putting that in as a service for our clientele and others.
Yeah.
So like I said, so one good thing is it's at least one and done. The other good thing, it gives all of your members and potential members an opportunity to revisit and look at all of their governing documents and make sure they're up to speed. It's a great time to do inventory. I can't believe that I look at that. I'll see a cap table on a corporation that was formed 10, 15 years ago. And there were four owners then. Two of them had passed. All right. It moved into some trust for something else. Another guy sold his interest to someplace else. And the cap table was the same as it was 15 years ago. So that is not good. So you need to bring all great opportunity. But the other thing that's important, not only the cap table, bring them up to speed. We now as a company, so when we formed our new company, Lori, Harry, Paulco, in our operating agreement in our LLC, should be a new section called Corporate Transparency Act. And it says that the members shall comply with the company requirements in reporting this information to the Financial Crimes Enforcement Network. You sign that. If you want to be a member of our entity, you've agreed to comply, or you cannot be a member of our entity. And if somebody wants to become, we want to sell some of our membership interest to somebody else, they have to agree to comply. If they don't comply, or we'll buy them out at 50% of book value. We can't have them because it could bring red flags to us under this act. And so that's a good thing to get that inventory done. It's a good time to do that in this morass of a problem. Another issue is that is a high concern is look at all the information that's running around. The information that's being transmitted from you to, for example, to your law firm, and your law firm then transmitting that to the Financial Crimes Enforcement Network website has to be done electronically. They won't accept it any other way. And that information needs to be encrypted. It needs to be held in a vault in an appropriate portal. You have to secure that information because do we have bad actors out there? Even on FinCEN's website now, it says, beware, scams, bad actors are trying to steal that information. So now we get into all cybersecurity, which is now enhanced because we have, and now you can see 33 million businesses winds up being 150 million BOIs. All right.
Yeah,
And
Harry,
all
they've
that
got that
information
alert up there. They still
yeah,
got it up there right now. I'm looking at it.
it's an alert. All that information is floating all around the country. My God, that is just a big neon sign to bad actors to do that. So you have that kind of impetus for cybersecurity and protection that comes as a result of this. So where do I think it's going? I do think that there will be some challenges. I do think there'll be some modifications. I think that one of the bills that is now moving through Congress, it's interesting. So let me share this bill. So this bill's been passed by the House, not yet passed by the Senate, and not yet signed by the President. So this bill is mostly about time frames. It says that, well, we don't think there's any way on the planet that we're going to get 33 million companies registered by December 31st, 2024. So we extend that to December 31st, 2025. So it gives us another year for the pre-existing entities. And the other thing it changes is changes. So a change of address, change of status, we have under the current act, the way it's only 30 days to report a change, not enough time. So they're looking to extend that to 90 days to report a change. So that's the main gist of this act going through Congress. But there is of course, a draconian aspect of it written in English that nobody can understand, which basically is of an instruction to FinCEN, the Department of Treasury, and the Financial Crimes Network, with a strong admonishment that they cannot accept any exceptions. There are no exceptions. If someone is not a complete picture, okay, or if it's intentionally not a complete picture, $591 a day, and we want that criminally prosecuted. So we have to get it resolved. And I don't know. I think that's a component that how could we be held criminally liable because we have a recalcitrant member in our LLC who say one of those, I'm going to go live in a bunker with 2 shotguns and I got special food and I'm not giving them that information. And we can't buy them out. They refuse to sell. That's under state law. We're not in compliance, and now they can be subject to fines and penalties. Um, I understand that, but we can be subject to fines and penalties for not being in compliance as an entity. I think there's a disconnect there, and hopefully that will be corrected either judicially or in some future component of legislation. So, so with that, I think you got a pretty good picture of what um, this looks like. And Paul, I think you may have some questions that you might want to ask, or people have any questions. It's time to do that. But there it is in a nutshell. That is the Corporate Transparency Act. It is a big deal. But remember, it's not public. It's for law enforcement, or they just want to, who are the human beings behind the entity?
Yeah.
Yesterday, I presented to another group. Just let me say this one thing, and it's a payroll service, and it was one of the attendees, and they said, we sometimes have a very difficult time. We're moving around $12 million, $15 million worth of payroll, and between accounts, and sometimes we don't know, we can't figure out who the beneficial owners are, and we have an obligation to do so. And she said, there has been bad players there. There have been bad players who've using payroll money nefariously and improperly. So from that respect, the judge in Alabama put it properly. He says, sometimes the government passes nonsensical laws, they said, but they're constitutional. He said, and sometimes they pass laws that are very noble in purpose. That this is a very noble purpose, makes us safer, but it could be unconstitutional the way in which it's done. So with that, I'll take questions. Do we have
Lori, I've got some questions that were sent in, but Lori, do you want to expand on anything there? Any questions?
It just sounds so complicated.
Well,
And it's good
sometimes
to
it's
know that,
simple, Lori. Sometimes it's
yeah,
complicated. Hey, if we just have a piece of property in our living revocable trust, there's no reporting. If we have a LLC there, that you and your spouse, for example, are the members, the manager, and it's in your living revocable trust where you are the trustees, with the kids as beneficiary, it's not that complicated. You got to
yeah,
do all that stuff, but
yeah,
because all the control and all the ownership are all lined up, and it's the same people. And once
yeah,
you report one, and by the way, it's an individual reporting. In other words, if you have a holding company that has 9 entities, it's 9 individual reporting. It's not the holding company can't report for the 9. And when
yeah,
you may say, Lori and spouse hold all these positions. We can't just do an omnibus. Each position has to be Lori and spouse, Lori and spouse, Lori and spouse, Lori and spouse, Lori and spouse to do it.
yeah, yeah,
Very belt and
yeah.
suspenders like.
Lori, you were going to say, yeah.
No, I'm so glad to have you here and start spreading this word because there are so many people who have no idea uh, that they have to do any of this and the consequences. So, I mean,
Yeah.
it's very, very impactful, as you said.
Thank
Yeah,
you.
and here, so the question, just to expand on that a bit, is you recommend for like Vistage quality or level companies, first blush, as many of them said early on, well, I don't qualify because of revenue and headcount. But then when you start getting into the brother-sister entity relationship where you are carving out IP from a company, you're carving out, trucks, from a company, so it limits the liability. That's when you create those brother-sister entities,
Yeah.
and they are subject to filing.
Yeah, the big concern that we have, as attorneys that are in this field, um, is the hopefully that the Corporate Transparency Act does not put a chilling effect on people doing the right thing for their estate planning and their asset protection. So saying, hey, look, I'm going to put that real estate in my company. It's not a good idea because you have a liability of the company use real estate. Proper estate plan asset protection is to get it out of the company and lease it back to the company and then have it held by an appropriate trust. You create a reporting entity once, but it's the proper thing to do. And people in protest of this act may stop doing the right things and cause them unbelievable personal liability, and to the point of bankruptcy and terrible estate planning for the wrong reasons. We see that all
Yeah.
the time, and we see that even in the first 90 days of this act. Oh, I'm not going to create an LLC or these 3 LLCs or these limited partnerships. I'll just keep it in my own name because I don't want to report. That's bad.
Yeah.
That's a bad sign.
Yeah, excellent. I love it, Harry. Great information. Lori, thanks for making this happen for your network. And I want to just stress for everyone that we are recording this, and wherever you're watching this, because it live streams everywhere, you can get connected to Lori and Harry around this video. So thank you, both of you. Appreciate it.
Thanks, guys.
Yeah. Thanks
Appreciate it.
both to you.
Thank you.
All right.
Bye-bye.
Have a good day.
Bye-bye. You too.
Bye.